Hello, everyone. Welcome back. This is James Anderson of Anderson Law Firm here in beautiful downtown Fountain Inn. Today, I have a special treat for us. This is part 3 of our ongoing estate planning fundamentals series, which I affectionately refer to as Dave Ramsey's Curious Estate Planning Advice. Again, today's part 3. Here we're talking about gift giving mechanics. Do we make gifts outright or do we make gifts in trust? And if you know me, you know that that I am an estate planning attorney. You know that is far and away my favorite thing as an attorney to do, and this is my favorite thing to talk about. And I really do hope that sincerely that some of my enthusiasm for this subject matter rolls on over to you or rubs off on you, because really, what we're about to talk about today is solid gold. This is good stuff. And to get you caught up, if you haven't been watching if you have not watched the previous 2 videos in this series, I'm kind of picking on Mr. Ramsey. Don't want to knock him. I have friends and clients, and even better, friends who are clients who have greatly benefited from his money management and budgeting advice. But you know what? The man's not a lawyer, and he is not an estate planning lawyer. And as a result, when asked, there are some specimens of him giving some really spectacularly bad estate planning advice. And I can show you, probably a dozen or more specimens of that. But for the sake of brevity, we're just going to, recap. I think probably my favorite specimen here. And again, if you've not watched the previous 2 videos, I have a transcript here where, a caller calls in, says, Mark says, ask Dave to explain the difference between a will and a trust. And Mr. Ramsey's answer is, everyone needs a will, but not a trust. You leave money in a trust by virtue of your will. The will tells everyone what to do with your stuff and your kids when you die. The will can say, leave the money in trust for your kids. You need a will, but not necessarily a trust. This is great. The living trust costs up to $4,000 and is highly pitched, but it's overdone in the estate planning world. It's not needed nearly as often as people say. It's more of a gimmick. You save on probate taxes, but you operate your life in a trust, which is a pain in the butt. And again, I'm not really gonna micro analyze all that's going on there, because that's what the previous 2 videos have been there for. But again, if you're just starting with us right now, to get you caught up, and in order for us to unpack this conversation, we first took a look at, just what does a will do, and how does a deceased person's stuff get out of their name and into somebody else's name. And we talked about the fact that when someone dies, their assets are going to get out of their name and into somebody else's name, really in one of a handful of ways. It's either going to go through probate, which is the default county level bureaucratic mechanism for that, or it will pass by operation of law, because there's some law that applies that says where something's going to go when someone dies. Or it could be by operation of contract, like a beneficiary designation on a life insurance policy or a retirement plan. Okay, and again, we spend several minutes talking about that in our first video. So if all this is confusing to you, if you don't know what probate is, stop this video and go back to the first one. Okay, but where wills come into play, we talked about how the function of a will is merely to direct traffic for us in probate after we've died. Wills only control those things that go into probate when we have died. Okay, and the thing is that the vast majority of people out there don't understand that, and because they don't understand that, they tend to give more credit to wills than what the will itself actually deserves. And we see Mr. Ramsey's comments on this subject as an example of that. All right. And again, in the first video, I think I spent the bulk of my time really talking about the negative consequences that tend to flow from not having planned for incapacity or healthcare concerns, and that how the negative consequences that tend to flow from not having planned for incapacity tend to be a whole lot worse than the negative consequences that tend to flow from not having adequately planned for what happens to our stuff when we die. that's not important, but and again, go back to the first video to see what I'm talking about. Living person's probate tends to be a whole lot worse than dead person's probate. And so because of that, ultimately, I made a conclusion. I shared, my opinion, which was that in my mind, actually for the vast majority of people, if you're going to prepare, just one estate planning document, forget about the will. Get yourself a good, appropriate, durable power of attorney and healthcare directives. All right. And again, if that doesn't make any sense to you, go back to video number 1. As we moved into video number 2, we actually started to take on this whole will versus trust dichotomy head on. And at the end of the day, the moral of the story is a good trust-based estate plan offers us at least 2 core fundamental advantages. The first is that whatever you do put into your trust while you're alive is handled privately under the terms of the trust agreement and does not have to go through probate to get out of your name and into someone else's name. Okay, so really what the trust does is in one fell swoop, it takes the place of your wills and probate. Okay, and that offers us an administrative advantage. Contrary to Mr. Ramsey's commentary, the stuff that's in that trust is still yours and you still control it. So it's not a pain in the butt to, keep assets within the trust and maintain the trust as such. And you're free to change the thing. That's why they call them living trusts, is because, they run alongside us for the balance of our life, and we can, in fact, continue to control them, and they can live and breathe and adapt alongside us. Okay. Now, the other core advantage of the trust-based estate plan, and this is really getting into kind of the 30,000 foot, a bird's eye view, long picture advantage of a trust-based estate plan, and that is that not only does the trust keep things out of probate, but if you imagine all of your assets being funneled through one common trust conduit at your death, all those assets that flow through that trust are going to be handled privately. They're going to be handled privately in terms of the trust agreement, yes, but they're going to be handled under a master set of rules and plans and contingency plans and contingency plans, right? So if someone who was supposed to survive you did not survive you, that's terrible, but you already would have planned for that at the trust level, right? And this is where we left off last time. Over and above that, that type of platform gives us an opportunity to very efficiently further structure and protect the gifts that we leave from potentially well beyond the grave. Okay, and this is where the estate planning magic happens. This is the fun side of estate planning. So strap yourselves in, get ready. Here we go. All right. Now, first things first. When we die and we're going to make gifts to somebody, be it to a spouse or children or grandchildren or to your favorite lawyer, whatever the case may be, there are 2 ways that one can make gifts from the grave. The first way is we make outright gifts, and outright gifts are far and away the most common way that gifts are made when someone dies. It's so common that we tend to assume that that's just the way it's done, and that is the really the legal equivalent of stroking somebody a check from the grave, or signing property over to them from the grave. What was once ours is now theirs. Okay, it's theirs. It's absorbed into their estate, and we've now lost all control over it. We don't get to continue to shepherd or control what we have from the grave. All right. And I refer to outright gifts as plastic BI-LO grocery bags of cash. They're flimsy. Yes, it's easy and intuitive. You can tote the bag around with you, whatever. But that plastic bag is not going to offer that inheritance any protection from the elements. Okay, so I say, even though it's the most common way to make a gift, it's also a really lousy way to make a gift, because You leave that inheritance for someone out there exposed, naked as a jaybird out there in the big bad world. Okay, there's no you're not going to be able to control or protect that. In the event that somebody gets divorced down the road or gets sued, and you can't protect people from themselves if that's an issue. And in fact, it is an issue, whether you think it is or not. It is. Okay, it's a big bad world out there for inheritances. All right, I did a quick Google search about inheritance statistics earlier today, and I saw some good headlines. Here we said, 1 in 3 Americans who get an inheritance, blows it. Here, 70% of rich families lose their wealth by the second generation. I'm particularly partial to this slide. Here we got a screenshot from one of my all-time favorite shows, Arrested Development. So here we see 2 generations of the Bluth family, and if you ever watched that show at all, and you get to know that daughter's character, I think you're safe to assume that she's got no business actually being in charge of any of her own inheritance. So it's kind of fun. I've been living with my mother-in-law for the last month and a half while my residence is being renovated, and I've made an Arrested Development fan out of my mother-in-law. So that's I guess that's been my civic duty for the year so far. But I digress. 70% of rich families lose their wealth by the second generation. There was a similar study done in the 1970s. Where they also followed affluent families, watched as mom and dad died, watched as the wealth cascaded down to the next generation, to their children, and watched to see what would happen when the children died. And I think in that study, in almost 80% of the cases, the family wealth did not make it on down to the grandchildren's level. It evaporated at the children's generational level. And, that's a combination of a lot of things. That could be that the children are getting divorced out of half of that inheritance, and or maybe they're getting sued out of that. And, maybe they're spinning their way through that like drunken sailors. Okay? It's kind of like people that win the lottery. It's kind of like professional athletes who maybe at a young age come into, these enormous pro sports contracts. One way or another, financial windfalls, when money falls out of the sky, unearned money, as some people call it. Whenever you see that scenario, statistically, the money just doesn't stick around. It gets gone. As a matter of fact, I personally am privy to a situation close to me where someone inherited about $1 million and burnt their way through it, or at least through $800,000 of it within the first year and a half. Okay, so if you don't think it can happen to your children or to your grandchildren, well, I hope you're right, but the statistics don't back up your perception of that situation. So and we can go on, but the issue is that we don't have to leave it up to chance. We don't have to just fling money out of our name, from the grave. We don't have to settle for the sad realities that would come from us losing all ability to continue to shepherd and lovingly protect our resources for those close to us. We don't have to do that. And this takes us to the second way, really mechanically, that gifts can be made from the grave, and that is that rather than make an outright gift to someone, you can leave someone their inheritance in trust for their lifetime. I call these fortified piggy banks. All right, so a good trust-based estate plan would say, rather than, okay, well, I'm going to leave everything that I have to my children in equal shares, I'm going to leave that to them outright. You would say, well, I'm going to leave everything to my children in equal shares, but I'm going to set up a sub-trust, a separate, at this point it would be an irrevocable trust for each of my descendants, and to put each descendant's share in that separate trust. All right? Now, what happens then is that their inheritance is there for them, if that's what you say. Maybe there for them and nobody else, there for their exclusive use and enjoyment for the rest of their life. Is there for them, but it's not theirs. Okay, it's there for them, but it's not theirs. The assets being transferred to them do not wind up titled in that child or that grandchild's name. It's titled in the name of the trust that has been established for their benefit at that time. Again, it's there for them, but it's not theirs. In a way, it's really still kind of yours. It's there for them, but it's not theirs. And if it's not theirs, a judge can't take it from them. And so we're unlikely to see a situation where if a child inherits and then their marriage fails, to where a divorcing spouse would be able to walk off with half of it. It's true that one spouse's separate inheritance is not supposed to be subject to equitable division in a divorce, but if the inheritance winds up being commingled during the course of the marriage, and guess what? It doesn't take much to commingle an inheritance. Then all bets are off. Okay, so divorce is a huge statistical risk, huge potential drain on family wealth transfers. But we don't have to worry about that when it's left in trust. Likewise, if someone gets sued, again that inheritance is going to be protected from my ambulance chasing brethren and otherwise. So this assumes that things are administered properly. This assumes that the trusts themselves are set up properly so as not to create liability pitfalls. But it can be done correctly. If done correctly, you can create something where you can better actually control and protect what you have from the grave than you can or I can while we're alive. And yes, I know that's counterintuitive and maybe a concept that you're not accustomed to. Well, that's why you're listening. That's why you're watching this. So if I can expose you to this option, then that makes me very proud, and I've done what I needed to do for the day. Okay, so we can leave our survivors their inheritance in separate trusts for the rest of their life. We get to say what happens to the balance of their trust fund if they predecease us or otherwise, if they survive us and then die. Usually it goes down to people's children, but it can go wherever you want it to go. So again, you continue to retain control. We're not worried about a son or daughter's inheritance moving out laterally to, say, in-laws at their death. Not that you don't have great in-laws, but I'm sure that if you have grandchildren, you probably like them more than you like your in-laws, and why wouldn't you? So if you leave someone their inheritance in trust, you get to control what happens when that person eventually dies, and you can keep it in your family if that is a priority, as it is for most people that I encounter. All right. And then there are different ways that these trusts can be administered. You get to define your own private set of rules as to how you'd want your estate to be leveraged for those close to you after you're gone. All right. A very common arrangement is to say, okay, trustee, I'm dead. You're in charge. I want you to allocate these resources for this particular person. Put the money, to invest it prudently, put it to good work, pay the income that the trust investments make out to the beneficiary over the course of the year, provided that they're an adult and they don't have problems, like substance dependence problems or gambling addictions or things like that. And then you might say, make the principal of the trust available. If they need more money, make the principal available. But do me a favor first and make sure that what they're looking for, relates to, a legitimate need that's consistent with them maintaining the reasonable standard of living. Okay. And you can deviate from that in all kinds of different ways, but, most people are happy with some version of that. Now you might say, okay, well, I'm confused. Who is the trustee? Would my child have to be asking somebody else for money? Well, it's up to you. It's up to you. And this is going to depend on what your concerns are. What might be keeping you up at night when you think about your planning or think about what might happen down the road. You could have a third party trustee, like a trust company. All right. And in that case, that third party trustee, they're going to be duty bound to follow your instructions and do exactly what you tell them to do. Because if they don't, they're on the hook for that. Right. And so you would have a lot of confidence knowing that they're going to handle things as you wanted. As I say here, that's the only way you'll know that your instructions will be complied with, and it's the only way you'll know that your loved ones will not become statistics with respect to their inheritance. Now, you might say, well, I just really don't like the idea of my children having to ask somebody for their money. I want them to be able to do what they want and control it. And if that's the way you think, then you'd be in line with probably 85 or 90% of my clients. The thought of having a third party involved, especially when folks haven't spent a whole lot of time thinking about it and thinking about the issues, the thought of having a third party involved is kind of intimidating and off-putting, and like, I don't need to do all that. And yeah, if that's the way you think, you're in the majority, and I understand that. If the trust is set up properly, you could allow for an adult child or an adult grandchild or whatever to be the trustee of his or her own trust. Now, you have to be careful with the way it's drafted, because you can blow the asset protection functionality. And then even when you are careful about it, there's still going to be some more limitations on the asset protection functionality. But again, if it's set up properly, you could allow for a child who got in trouble, maybe they had a liability coming down the pike, to resign as trustee and put a third party in charge and change the rules on how things would be administered, and that should go a long way towards still protecting the inheritance. So generally speaking, if things are set up properly, you could have a person be both the trustee of their trust and the beneficiary of their trust, and still afford a significant degree of asset protection. Now, the thing is, though, you're not protecting them from themselves. Okay, if they want to make bad decisions, you are still leaving the door open for them to make bad decisions. Okay. Essentially, what you're doing here is saying, on top of bequeathing you this money, this property, I'm also bequeathing to you an option, and that is that you can, you can decide what you want to do. If you want to pull all the money out of it, fine. If you want to squander it, fine. And again, most people I talk to are okay with that because they don't like the thought of basically hemming in their loved ones. Okay, but just be careful with that. I like to share the story of my paternal grandmother. So my dad's mom, she survived that grandfather of mine by 25 or 30 years. I never knew that grandfather. He died before my mom and dad even met. And like most people, when he died, he just kind of just flung everything over to my grandmother. What was his became hers. And you know what? It was okay. She never remarried. So no, we dodged all those bullets related to successor spouses and stepchildren. And so that's a pretty big bullet to dodge when you think about it. She was a pretty terrible driver. She really was, but she never got sued over that, so that wasn't a problem. She was not a spendthrift. She was this frugal Swedish lady, and she lived within her means, and she managed her money, fine. That was not a problem. But right there towards the end, dementia set in hard and it set in fast. And before anybody could figure out what was going on, a nice young fellow from the Australian lottery started calling. And long story short, she subsequently sent $300,000 to Australia to claim her winnings, which, surprise, surprise, never materialized. Okay? And when she died of pneumonia about 9 months after that, she was worth all of about, I think it was $38,000, and that was not even enough to cover expenses. All right? So now, if my grandfather had taken the extra step of doing some planning and setting up a trust for her at his death to put his estate into for her benefit, if he, like a lot of people, if he named her as the sole trustee of his own trust, I'll ask you, would that have changed the ultimate outcome? No, it wouldn't have, because mechanically there'd be nobody there to stop her from writing those checks to the Australian lottery. If the money happened to be in the trust fund that she inherited and she controls it, she's going to write that check as trustee and drain her husband's estate. Okay? But, if my grandfather had left it to her in trust, and if he had put a trust company in charge, no trust company worth their salt would have ever written those checks to the Australian lottery. Or even if he had just appointed my dad and or my aunt alongside my grandmother as co-trustees, I'm pretty confident that neither one of them would have ever co-signed any checks to the Australian lottery. And yeah, that would have made my grandmother angry, but at this point, who cares? At least that family catastrophe would have been averted. So, something to think about. And so maybe at this point you're saying, all right, well, talk is cheap, James, but what have you done? I'm glad you asked. So, if you don't know me, my wife, her name is Kate. Kate and I, we don't have any children. Wish we did, but we don't. We have our 100-pound lap dog and our 19-pound tabby cat. But that's the closest thing we have to children, and the law doesn't treat them as such. So we won't either for our purposes here. So my main concern is that if I predeceased dear Kate over there, that I want her to be set up in style, so to speak. So what have I done? Well, as you might imagine, I've got one of these gimmicky trusts myself. Go figure. I have that trust so as to streamline and privatize the administration of my estate following my death. I've got all my life insurance and stuff like that, pointed into the trust through beneficiary designation. So if I predeceased Kate, everything I have would flow, through that common conduit there. I am well trained. I've got everything going into a trust for Kate's benefit. So as I say, I'm well trained. Everything is going to Kate. It's going to her in a separate trust for asset protection purposes. And guess what? Kate's not the trustee of her own trust. Now, is that because I don't trust her? No, I do. Is that because I don't think that she would be capable of managing her inheritance? No, she is, and she would. She's quite crafty, in fact. No, that's not what it is at all. What it is that at this point in my life and in my career, my mind is warped. I am capable of entertaining any rose-tinted notions about what would happen to my stuff after I was gone. Okay. So, I have at least, 3 strikes against me. First strike, I am a lawyer. I did go to law school, trained to, look at the worst case scenario, and I do. And here in the office, this being what I do for a living, we see these worst case scenarios, right? And I suppose the third strike against me is this thing with my grandmother and the Australian lottery, right? So anyhow, I want to put myself in a position to where I can put my head on my pillow at night and sleep and not worry about all the what ifs. For instance, my wife and I, we share at least one common personality flaw, and that is that we're both overly accommodating. We don't like telling people no, and it gets us in trouble from time to time. And you know what? It would make Kate, if I died and word got out that I had died, folks are going to start coming out of the woodwork wanting things from her, aren't they? And you've probably seen these things yourself. Well, here's the thing. Kate can say to somebody, well, so and so, I understand your situation. I'm very sympathetic to your plight. I would love nothing more than to buy up your daughter's unsold Girl Scout cookie inventory. I really would. But you know what? James left his stuff in a trust, and there's a trustee. And I talked to the trustee, and he says he's not authorized to write that check. I'm so sorry. And so she sidesteps it, right? It's not her. It's mean old James from the grave through his trustee saying no. And hopefully, word would get out around town that it doesn't make any sense asking Kate for money because you're not going to get any, right? And that's what I would want. Kate's, as you see, Kate's young. If I up and died, I'd hate for her to trudge on through life by herself. If there was some, I don't know, suitable successor companion out there for her. At the same time, I don't know who she might marry. I don't know if she's going to marry Charlie Hunnam over there from Sons of Anarchy fame. I don't know if I'm going to like him. I don't know what his agenda is. Well, guess what? The reality is that Kate can turn to Elizabeth Taylor after I'm gone and marry and divorce 8 times without a prenuptial agreement, and the inheritance is there for her, but it's not hers. If it's not hers, then old Charlie Hunnam over there can't take it in a divorce or otherwise. So I like the sounds of that. So no inheritance for you, sir. Maybe Kate takes up with a googly-eyed Abercrombie and Fitch model who wants to vacation in Bora Bora. Well, more power to them. All right, but they're not using my money. They can, if it's old Charlie there, they can use his Sons of Anarchy money to finance that trip. Okay, and hopefully Kate would live a long life. She has longevity in her family, as I do in mine. With the exception of that one grandfather. But if Kate lives long enough, or if I live long enough, or if you live long enough, dementia awaits us, doesn't it? And the day we get demented is the day that the Australian lottery, or the Jamaican lottery, or the Bora Boran lottery, they come a-calling. Well, I don't have to worry about it because the trustee's not going to write those checks. Okay? Now, you might say, okay, James, well, how do you have your own stuff set up? Well, you better believe I've put myself on the receiving end of the same type of plan. Okay, I'm actually probably more worried about me than I am my wife. You ladies out there, you're tougher than most of us men are. Not saying that widows don't grieve and have a hard time, but it does seem that widows are better equipped to grieve, and also kind of they tend to kind of keep it together. Widowers tend to struggle more, and I think that is why statistically a widower is a whole lot more likely than a widow to remarry, frankly. And so I'm very dependent on my wife, and I know that I would be quite a specimen of a widower, and I don't know what kind of dumb things I might do. So if in a moment of loneliness and self-pity, if I go and take up with some Latvian mail-order bride, and I import her here to Fountain Inn, and it turns out she's not the nice lady I thought she was, and I have to divorce her. Well, she might clean me out, but she's not gonna erode my dear bride's estate. And I get a weird sense of comfort from knowing that no matter what stupid things I might do in the balance of my life by myself, if I survived my wife, I've inherited a fortified cash flow machine that I cannot destroy, even if I wanted to. Okay, so now, am I saying you need to do the exact same thing that I've done? Absolutely not. As I always say, different strokes for different folks. People are different. Priorities are different. Objectives are different. Okay, there's no right or wrong approach to this. But hopefully, as you have, I hope, perused all three all three videos in this series, hopefully we have educated you and broadened your estate planning perspective. The more you know, the more empowered you are, and the better decisions you can make. And again, you don't have to set things up the way I have, but make sure you do talk to your lawyer, or if you don't have one, by all means, come on down. We can sit down and discuss it and go over your options and really try to figure out what's going to make you happy, what's going to make you sleep well at night, what is going to have you sit up straighter in your chair, and what's going to send you out of my office with a spring in your step and a smile on your face. Because if we do our jobs correctly, that's what's going to happen. And that's what will make you happy, and in return, that's what will make me happy. And really and truly, that's why I do love doing what I do for a living. It's great. Anyhow, thank you for watching. Thank you for your patience, and we'll talk again soon. Take care.